morning, everyone. Thank you so much for joining us. My name is Maya Fleischman. I am an associate at the Birmingham office in Baker Donaldson. I am also, I do construction and labor and employment, and I am joined here with my colleagues, Beth Weiner and Cameron Hill, who are going to introduce themselves. Cameron?
Thank you, Maya. Good morning. My name is Cameron Hill, and I am in Baker Donaldson's Chattanooga office. I have been practicing largely construction and employment litigation since about 1997, pretty much exclusively what I do. And I appreciate you all's attendance this morning and looking forward to talking with you about this interesting topic.
And I am Beth Weiner. I am in our Baton Rouge office, and I have also been practicing exclusively labor and employment for about 10 years and do a great deal of work with construction industry clients. So thank you all for being here with us today, and we hope this is useful and insightful for you all.
All right, before we get started, we're just going to do a few housekeeping notes. There is going to be a Q&A section. Y'all can type in any questions you have in the Q&A box at any point. You know, it might be we're going to have a really lengthy discussion. This could be interesting and enlightening, so we might answer some of your questions along the way. If there are any questions that haven't been answered in time allotting, we're going to reach them at the end. And as soon as this is over, you're going to get a PDF presentation of the entire webinar, so you will have access to all the information that we talked about in the PowerPoint slides. Okay. Like I said, it's going to be a really interesting and enlightening hour. We're going to talk about, you know, the EEOC's investigation and focus into the construction industry and why they're doing this and what types of cases they're looking at. We're going to talk about some of the consequences, which include consent decrees. We're going to talk about what's a consent decree. And overall, we're just going to kind of talk about what these investigations can look like and more so how your business can be prepared. Because at the end of this, we want you all to be informed and know how to protect yourselves and help your business so y'all can grow and be successful. I'll be asking, this is going to be a Q&A format, and I'll be asking Cameron and Beth questions along the way. And hopefully I can answer some of the questions that have been on your minds. With that, we're going to go ahead and get started. Well, first of all, I just want to say, Cameron, Beth, thank you all so much for being here today. Y'all are really experts in the field, and I'm really excited to hear what you have to say. So we're going to talk about why we're here. We know that the EEOC has a 5-year plan to focus on the construction industry. Why is this a big deal? Cameron, maybe you can shed some light on that.
Maya, thanks. The EEOC is devoting a lot of resources to this effort. And in large part, what it will be doing over the next 5 years is coordinating throughout the industry at multiple levels across the industry, down to the union level, down to the training programs at the unions, not just the employers, but the entire industry. There will be community meetings, there will be outreach, there will be coordination among local governments, regional offices of the EEOC, et cetera. There will be a considerable amount of effort placed on this for the next couple of years. And what we wanted to share with you all today was sort of why this is happening and what the impacts may be on you and your career and your business, some of the things that you should be looking out for. Because certainly there are significant consequences that can come from an EEOC investigation. Very practical consequences, very substantial, long-lasting consequences, not only to the businesses themselves, but to the employees. And we fully believe the EEOC, as we will talk about throughout the rest of the morning, will be spending a considerable amount of time investigating the construction industry across the country. No state, no jurisdiction is immune. The EEOC will be looking throughout whatever it can try to find to help correct some historical issues that it has observed. Beth, would you like to add anything to that?
I think, one point would be that the result of the EEOC's focus is that if an EEOC office receives a charge of discrimination filed against your company, that may be viewed very differently than it has in the past. It may make its way to the top of an investigator's stack of charges to review. It may mean that because of this focus on the industry, that investigator might dive in a little more deeply in an investigation. And we'll talk about what that could mean a little later, but I think those are some of the reasons why this is a big deal. And the consequences of defending claims brought by the EEOC, which is another possibility that could stem from this focus, can be quite costly to your bottom dollar, to your operation, to employee morale. Defending a case over a period of years can really hit your bank account pretty high.
Yeah, that makes a lot of sense. And I guess, we know that the EEOC is really focusing on investigation, but could this increase the likelihood of other lawsuits from occurring or other lawsuits being brought?
I think the answer to that is absolutely yes. The EEOC has indicated that part of its initiative is going to be community outreach. It's going to be advising and training individuals in the industry on their rights, and I think that's going to lead to an increased number of charges just from a heightened awareness standpoint. I think other things we can expect is there is an aversion among the EEOC toward dispute resolution programs. I think that aversion may quite likely lead to them taking on and filing lawsuits on behalf of groups of employees who would otherwise have to bring their claims individually. So I think there are many possibilities that could come from this, including individual lawsuits. In addition, those dispute resolution programs that I've mentioned have served in some instances as what I like to call plaintiff attorney bug spray. But as a result of the pending Forced Arbitration Act, those dispute resolution programs are no longer the mandatory dispute resolution programs are no longer applicable to sexual harassment claims. So you may have situations where plaintiff's attorneys can pick up cases following an EEOC charge being dismissed and a notice of right to sue issued, and pulling those plaintiffs in and creating a class action, which can't be broken up using such programs in the cases of sexual harassment claims.
Yeah, given that, typically the government agencies' investigations are public record, I've already experienced where a plaintiff's attorney will get the names there, will get the company name, and then start picking off potential plaintiffs to form a class. And I've already seen that starting to happen, and I'm currently defending a case just like that. So I want to move on, and I know that the EEOC is looking into construction, and my next question is, well, why construction and why now? And Cameron, if you could shed some light on that, I'd love to hear from you.
Sure, Maya, thank you. And I'd like to start by mentioning one additional thing that I wanted to add to the question you posed a few minutes ago about whether there may be other litigation. Beth may have said this, but if she did, it's worth reinforcing. The EEOC has at its disposal other remedies available to pursue against companies than does a single plaintiff or a group of plaintiffs in a traditional litigation context. And we'll talk more about some of the impacts of what those are here in a minute when we discuss some of the consent decrees. But that's a very significant reason why we wanted to spend some time with you all today to talk about what the EEOC is doing, because once it gets active and once it has targeted an industry, you can expect substantial scrutiny. Periodically, what the EEOC does is find an industry that it believes it can affect change. And historically, the EEOC has found that women and people of color are underrepresented in the industry. And given the substantial amount of resources that we spend in this country on an annual basis, which is in the trillions of dollars on construction, that the EEOC wants now to try to implement change. It wants the construction industry to look more like America. Racial percentages, and I'm not talking about getting specific numbers, but it wants to see better representation. In approximately February, March of 2022, the EEOC announced that it would be targeting the construction industry. It has a 5-year plan. That 5-year plan does not have a hard start, and it definitely does not have a hard stop. The EEOC will continue devoting its time and resources to investigating the construction industry for pretty much as long as it feels like it's necessary to do it. What it wants to see is change. It wants to see statistics change. It wants to see data change. It wants to see less litigation brought related to harassment and discrimination in the construction industry. Beth said this earlier, and I think it's very worthwhile repeating. Other types of the EEOC initiatives are not going away. The EEOC will continue to investigate other types of industry, other types of businesses, but it has chosen the construction industry as its priority for the next 5 years. So for the next 5 years at a minimum, you can expect the EEOC to take very seriously any charges and claims brought by individuals to the EEOC. Those that are brought directly to the EEOC will get heightened scrutiny by the EEOC, and you can expect there to be a lot of reverberations across the country.
Do we think that because oftentimes construction companies contract with the government and a lot of public dollars go into it, do you think that has something to do with this scrutiny as well? Is that something that you can speak to?
So my thought first is that yes, but when we talk about contracts where federal dollars are being provided to complete the contract, certainly the DOL and the OSBCP are involved there, and there is significant audit authority, and certainly that has always been the case with respect to those types of projects. But in addition, what we've seen over the last few years is some bipartisan infrastructure investment in acts like the Jobs Act of 2021, the CHIPS and Sciences Act of 2022, and even recently the Inflation Reduction Act, all of which are focusing on federal investment in infrastructure. And this I think has heightened the EEOC's and other agencies' interest in the industry. These federal dollars are part of the reason for the focus, I think. And just to put it in a little bit of perspective, in the next decade, the EEOC has noted that it anticipates construction and extraction occupations to increase by 4%. And this is new jobs, not job openings, job turnover, but something in the range of 252,000 new jobs are expected during that time frame. And they say they want to see those jobs being taken by people of color, women, those who are underrepresented in the industry at this point, according to the statistics noted in their report. They also pointed out that in 2022 alone, seasonally adjusted public construction expenditures equaled approximately $4.35 trillion. And, that level of dollars, the level of tax implications that could mean with respect to tax credits, tax benefits that are being included in some of these infrastructure investments, means that they want to see those tax dollars or those dollars that are at issue going to benefit the country equally and be open to all qualified workers. Now, another piece of this on the why now, I think, is because of a lot of the cases they cite in their report. The fact that the cases range for over a decade and involve a lot of the same barriers. I think that's part of the reasoning too.
So what are some of the problems, and you're talking about the cases that they've cited in their report. What are some of the problems and issues that they've identified in the industry? And what are they planning to do about it?
Yeah, to expand upon one thing Beth said,
okay.
The EEOC historically looked back and found that there were substantial barriers to entry into the construction industry to women and people of color. The women and people of color who got into the industry were then discriminated against or suffered other kind of harassing behavior. And third, there were barriers to growth. They weren't given the same opportunities to advance within the industry. So those are sort of the three largest themes that have propelled the EEOC to spend a lot of time on the construction industry now. You know, I saw one question pop up in the Q&A about whether there are certain, the construction industry is not one size fits all. There are different types of construction companies, different levels of sophistication, et cetera, and some concern about the application of stereotypes to all construction. I certainly agree with that. However, I will tell you, based upon the survey of the cases that we have performed and the types of cases that we see and help our clients with on a routine basis, there is no part of the construction industry that is immune to this. The EEOC will be looking at any and all parts of the construction industry as it starts to try to find ways to make the construction industry better. Now, certainly the companies that are better prepared, that have done a better job addressing preventative behavior, policies, procedures, training, things like that we will discuss later on, those companies will be better positioned themselves to avoid the type of scrutiny that's coming down the line. But I don't believe any part of the construction industry is going to be immune to the EEOC's attention.
And Cameron, I want to tack onto that because I agree. It was a great question. And I think that, you know, one part of it was what can a construction company do to distinguish itself? And I think that in reading the cases, in reading sort of the anticipated steps the EEOC is taking, the biggest thing that such companies can do is think outside the box. You know, we'll talk later about, you know, check your policies, check your toolkit, do your training, all the things, but think outside the box too. And we've got some ideas and suggestions there because, like you said, no segment of the construction industry is going to be immune from this focus, but also the turnover rates, the nature of the industry, the cyclical nature of hiring and layoffs and rehiring means that you're going to have people coming in and out, and you don't necessarily know what you're getting in connection with those people and whether they're going to abide by those policies. And so what can you do to distinguish yourself? Well, there are coalitions, there are partnerships, and the EEOC is going to be looking to work with stakeholders in the industry, and being willing to do that and not afraid to do that is probably a big help. You know, the devil you know is better than the devil you don't in many cases. And then, you know, another piece of it is in the report, you'll see that many of the companies who were focal points once saw later investigations again, saw later suits again. So knowing that staying off their list or their target list is ideal, but also, you know, developing those relationships with your regional office can be very helpful, because if they're aware of the efforts you're making to not only be compliant, but have an excellent culture, that's going to go a long way in avoiding being a target.
Yeah, it's a great point. The EOC's focus is grassroots. It's starting at the bottom to try to educate and inform as many people as it can about what these issues are. It will be working directly with people who are entering into the union apprenticeship programs, for example. It will be partnering specifically with JATC programs to make sure that they understand the impact of what the EOC is trying to do. So this overall heightened awareness is going to increase a lot of opportunity for people to engage proactively. And I think Beth's suggestion of, the devil is a good idea. Look for opportunities. We can talk about this in more detail later, but look for opportunities to be proactive by partnering with some of the people who are helping make these decisions, like the regional offices, your construction industry groups like the AGC, NECA, whoever it is out there that you can work with. But first of all, also, and we'll talk about this in more detail later, look at your home first. Figure out what you've got going on at your shop first. And the more attention you spend there, the better it will be to avoid these situations and issues.
Yeah, that all, it sounds like we definitely have a lot to talk about, a lot of things that, companies can start to do to kind of make sure that they avoid litigation. So I guess right now I kind of want to take a little step backwards and think about, well, what did companies do that even drew the attention of the EOC? And I know, Cameron, that you briefly mentioned that there were 3 types of issues that really brought attention to the construction industry, but I really want to kind of dive into the specific facts of some of these cases. So Beth, I think, this is a Louisiana-based case right up your alley. If you have any experience or can kind of speak about what happened here.
So as I mentioned, part of what I think the EEOC focus stems from is sort of a long period of time seeing similar issues and similar complaints. And this is a case that was filed, I think, in like 2011. The parties eventually entered into a consent judgment. It involved harassment, taunting, sexual harassment of a sexual nature. It was an interesting case in that it was a male superintendent accused of harassing a male iron worker before the decision of the Supreme Court that clarified that sexual orientation and transgender are protected under Title VII. So it was an interesting case in that there was a lot of back and forth and appeals. And, originally the jury held in favor of the EOC and awarded $451,000 to the EOC and the employee. Ultimately, after the years of litigation, they reached a consent judgment or agreed to a settlement of $125,000. And like I said, it's this historic case, and then you see it continue in some of the others.
And then I see here that, so that was more about sexual harassment. And I think, there's another issue that comes up a lot is racial discrimination. Cameron, do you have any experience with this, or can you talk a little bit, shed some light on this case?
Yeah, thank you, Maya. And this is a great example of what I think the EOC is in the process of doing. It wants systemic change. It wants a system that is different than it historically has been. So the resources that it will be spending, the time, money, effort, will be trying to actually affect meaningful change in the institution, but similarly being willing to pursue litigation as far as it thinks it's necessary to go. This is a fascinating case because it gets to the root of how the industry starts for a lot of people. The industry, as you all know, has a lot of union aspects to it. And the EEOC found that a Florida-based JETC program was systematically, routinely discriminating against Black applicants, just by literally failing to admit them into the program for a long period of time, a substantial period of time. And that, to me, is a perfect example of the type of thing of what the EEOC wants to do here. It wants to start at the threshold. If a barrier to entry is a problem, which the EEOC found that it was in this particular case, affecting change there so that the door actually opens and people can come into the office and come into the building and start working in the construction industry, that's what the EEOC wants. In this particular matter, it required an incredible review and overhaul of the applicant selection criteria. A very detailed amount of effort put into how to figure out applicants' qualifications. It included direct recruitment in the Black community. It required a few instances of actually going out and making public presentations, local high schools, civic clubs, things like that, inviting people to specifically apply. In addition to dealing with the people themselves who had been aggrieved, the former applicants themselves who did not get the opportunity. The EEOC required the union to go back out and ask them to reapply if they were still interested. A consistent theme that you'll hear when we talk about the EEOC's action is not only the consent decree part and all the injunctive type relief that it provides, but the monetary consequences. Here, the EEOC required the JETC program to pay $207,000 in penalties and fees for the behavior. So this is the type of thing that the EEOC is going to be focusing on a lot, the entry-level circumstances.
Yeah, and I want to chime in and point out that the IRA, the Inflation Reduction Act, has a lot of focus on use of apprenticeship programs, so I suspect we're going to see more of this. And I'll also point out, Cameron, you are exactly right on the monetary piece. I'll tell you, there was another case against a union in New Jersey during the same time frame where they ended up paying $1.65 million because of limiting available hours for work to apprentices in the program.
So yeah, it seems like these two cases that y'all are mentioning, talk about like not allowing people to work in the industry. And I want to shift over to like the actual treatment of some African American and Latinx folks who are working in the industry, and how some companies may have been treating them in the past, and how that's been brought to the attention of the EEOC. Beth, if you want to chime in and talk about this matter.
So in this case, it was a San Francisco-based company, and there were allegations that they had been failing to address and correct racially offensive remarks and graffiti all over their facilities and job sites. And as a result, they reached a consent decree. And we've talked about this as sort of, the EEOC has unique remedies, as Cameron pointed out. And one of those is this concept of a consent decree where they can continue to stay in your business. And it's subject to judicial review and enforcement. In this particular case, there was a requirement that a third-party EEOC monitor the policies, procedures, the implementation of those, the provision of training. So not only is the company investing in all of that and the cost of that and meeting those and complying with those requirements, but also it has this third-party monitor in the middle of all of its operations and has additional reporting obligations to the EEOC. So it can quite seriously impact operations and moving forward. And in this case, again, there was a significant monetary piece as well.
Yeah, I mean, these fees can be pretty high, and I mean, this company paid almost $1 million, we see, you know, and then I'm sure there's a lot of cost in having to go ahead and rework the internal policies and procedures and, you know, hire experts and things like that. And I think in this next case in New York, you know, they had to do the consent decree, you know, they had the monetary fine, and then they had to do a lot of other work to improve, you know, the inner workings of the company. So, I mean, Cameron, do you want to add anything to this?
Yes, thank you. A couple of things I want to mention here. The penalty or the monetary payment that is made is a factor of multiple elements. It relates to the number of people who have brought the claim. Is it a single person claim, or is it is it a group of people? The egregiousness of the conduct, how long the conduct lasted. There could possibly be some back pay involved, some constructive discharge issues. It just depends. There's really no specific formula for how to determine what the monetary consequence is. One of the things that I think is very important to keep in mind about consent decrees is the extraordinarily public nature of a consent decree. Not only is it going to be posted on, you know, our attorney databases, it is very, very often literally required to be stapled, pinned to the wall at the job site, in the break rooms, wherever the job sites are, not just a single job site, but if it's company-wide behavior, a posting at every job site of the conduct, the resolution, the fact that EEOC brought a claim. So it's a very, very public thing. I saw a question a few minutes ago about, you know, what should the industry be doing about this report? And I wholeheartedly recommend the industry review and study this report in great detail. Yeah, I would not be telling you the whole story if I didn't mention that I believe politics can be involved in some of this. You know, EEOC is subject to administration changes, so that is one of the things that occurs periodically. The EEOC will have a new leader, and the new leader will pick certain industries based upon certain political issues. But do not misunderstand me. I am not suggesting that the politics behind this is anything other than helpful for the industry overall and helpful for the country, because the country construction, the efforts of construction in our country are going to get this scrutiny. It's not a question of whether this is going to happen. It is a question of when it's going to happen. It is very, very likely that either your company or a company that you know and are very familiar with will be investigated by the EEOC. And once you have a public notice put on your job sites, everybody knows it. And that's going to hurt, as Beth mentioned earlier, that's going to hurt morale. It's going to hurt finding new employees. It could really slow down your ability to actually perform the functions that you're trying to perform out there.
And that's a really great point, because, you know, we talked about some of these kind of older cases and what happened, but now we kind of have to look into what types of cases are they, you know, investigating and prosecuting now? And, you know, how do we learn from these other companies' mistakes, right? And one of the cases that I, you know, studied a little bit and was reading upon was this case that happened based out of Washington State, where, you know, they talk about morale. I mean, there were a group of female employees who were being sexually harassed by the company's owner. And the women would report it to other people and nothing would happen. You know, there was no policies in place, nothing like that. They would report it, it would get brushed off. You know, when the investigation did occur, I think that one expert compared the situation or the work culture to a sewer, which sounds like a pretty bad place to work. You know, and from there, what happened was that the EEOC, you know, very recently, the EEOC and this company entered into a 5-year consent decree. And they really had to change their ways. They really had to hire a consultant, start all these, implement all these new policies and practices, implement training. One of the things that shook me was that they had to pay the maximum compensatory damages required by statute, plus back pay for one of the employees. So, it was pretty severe consequences. And these 5 years starting from June 2022, they're going to have to report pretty periodically. And it sounds like there's a lot of other cases like that. Beth, I don't know if you wanted to add anything to this particular case, or if you, wanted to.
I think you covered it. I think you definitely covered it. I would point out that, as you'll see from the ones we're walking through now that have sort of come down and been decided or been resolved since the EEOC announced its focus on the industry last year, there's still a running theme. The barriers to entry, the barriers to advancement and pay, the harassment and discrimination, it's still the similar type of charges that are being prosecuted and pursued by the EEOC. So I don't know yet that we'll see more systemic litigation spearheaded by the EEOC, or if it's going to be a willingness to conciliate, a willingness to work together with stakeholders in the industry. The EEOC in its report indicates an interest in working with stakeholders in the industry as opposed to utilizing only litigation or focusing more on litigation. And there was a question posed about this, so I wanted to weigh in from that perspective.
Maya, I'd like to add one thing that you mentioned and
Sure.
emphasized. This case has a 5-year consent decree. 5 years is an incredible length of time that you will have to be dancing with the EEOC. The number of reports, the frequency of reports, the degree of subject matter of the reports that have to be provided to the EEOC, the added layers of expense, administrative headaches, et cetera, that go along with operating under a consent decree for 5 years can be absolutely debilitating. When we talk about later some of the other aspects of a consent decree, I think to the extent you aren't familiar with what they are already, I think you will grow increasingly knowledgeable about why we want you to avoid them at all possible costs, and why the solutions that we really want to offer you today are preventative in nature as opposed to fixing the problem after it occurred.
So you mentioned that this case had 5 years, and we kind of talked about that's a long time. And I think earlier you mentioned it really is case by case, depending on how egregious the situation is. I see now that this next case based in Wisconsin was, a smaller penalty, still a pretty large, substantial penalty, but a smaller one. And then this was only a 3-year consent decree. Can you speak to maybe like the differences in this matter and why the consequences weren't quite as severe, but yet severe?
I think one of the main distinctions here was this was primarily a single employee case, as opposed to more of like the previous case with the HVAC company, which had more of an institutional problem, the way it treated women. What the consent decree, they follow general patterns. That there's no question that a consent decree follows a general pattern, but it will be tailored to the circumstances based upon how severe a particular case suggests the terms should be. But one of the things that often comes out of a single plaintiff matter like this is the obligation that an employer has to clean up the employee's personnel file. You have to make a neutral job reference. If someone calls and asks about the employee, it has to be a neutral statement. The employee personnel file cannot have a record of anything negative in it related to the litigation, the consent decree, or anything like that could be construed adversely against the employee. One of the things we've not yet specifically mentioned, but it's peppered throughout the entire list of consent decrees, is the injunctive relief that a consent decree requires. The consent decrees contain affirmative statements that company A and its supervisors, managers, owners, et cetera, will not engage in fill in the blank, whatever that discriminatory conduct is or that harassing behavior is. So during the consent decree, which, as you all know, the court has signed off on this. This is a court order specifically ordering a company not to perform and engage in certain conduct. So it's in some ways, it could be construed as setting a company up for failure unless it very actively, affirmatively goes out and corrects all of the problems that have been described by the EEOC in that particular case.
And that kind of brings me to my next question. I see that this consent decree in this Nevada-based case requires specialized training. So this seems to be a little bit more than just, these are the policies and procedures, take a quiz on these policies and procedures, and if you pass with the 70%, good enough. Can you, Beth, speak a little bit more to, what this type could look like, what these types of consequences can look like, and what it means for a company?
Yeah, and honestly, I'm going to echo what Cameron said in that each of these consent decrees is particularized to the facts of the case. And when you see specialized training there, well, in this circumstance, because the allegations involved many Latina women who couldn't speak English, complaining about unwanted touching, very graphic and offensive comments, sexual requests, the specialized training related to sexual harassment in particular. It related to the fact that human resource officers and managers weren't aware of how to handle and respond to the complaints at issue, and training those members of the management team on what they should be doing. And that is a focus of the EEOC's report, is that every level of management needs to be aware of the obligations and the need to follow the proper policies and protocols. And that goes even further back to, does your company have proper procedures and protocols in place? So yes, this is a great example of how a consent decree can be particularly tailored in a case.
What if there's just like one bad actor, one bad supervisor? Couldn't the company just fire that supervisor and then continue on? Like, why does it need to have all these other remedies in place? And here we see, Cameron, this Texas one, it seemed like it was just one supervisor who was problematic. And yet the company has to enter into this 3-year consent decree. If you could speak a little bit about this.
The EEOC generally, as a philosophy, believes that certainly the person who has conducted or acted the most inappropriately should bear a lot of the burden. But the EEOC also believes, and I think it has some justification for this, that the company has an absolute responsibility and obligation to make sure that all of the people it has hired who are in management level, supervisory level positions are not perpetuating discriminatory or harassing type behavior. So the short answer is the EEOC makes an example out of single actor cases because it generally believes that those actors would not be doing the things they're doing if the company had in place proper training, proper supervision, proper policies and procedures, and that people were educated and informed and knew from the outset what was appropriate versus inappropriate behavior and conduct. So as the case right before us involved a lot of people, in this case only involves a single person, it doesn't take away from the bad behavior that befalls a single person. The language, the jokes that were used in this particular case are terrible, and I will leave it to your imagination because you are right. If you assume what was said, you're correct. It was said. And so in that particular case, the EEOC says this behavior has to stop. We are going to emphasize that this behavior should stop. And because it was so severe, the company itself is going to have to submit to a 3-year consent decree. So whether it's a single case or a multi-party case, it certainly is behavior that the EOC wants to have stopped.
So this next case, I mean, it kind of goes to what you were talking about. If it's a single actor, it's usually a result of lack of policies and procedures. And here, the number is so large, I can barely even read it. And it seems like here was just an entire pattern and practice of the whole company to act this way. Beth, what do you think?
So in this case, there was certainly punitive damages at issue as to how the number got to where it is. Also, the nature of how this litigation went down, and defense counsel eventually withdrew, and there were several issues that led to a default judgment, meaning the court ordered judgment against them without the company getting really an opportunity to weigh in on that number. But I think what you pointed out is exactly right. It's the pattern and practice. And a couple of examples would be that this staffing company in Maryland had people at all levels making comments like, "We only hire strong men and not women," or telling women that if they get to the job site and someone hands them a broom, they shouldn't be surprised, coming from all levels of management. So it was pretty apparent that there was an absence of any sort of policy against that type of, barriers to entry for women in this particular matter.
So someone, interestingly enough, commented, do we believe that this will lead to a single splashy and big dollar case to teach the industry a lesson? I mean, this looks like pretty new, March 2023. Would you consider this one of those big, splashy, big dollar cases that are meant to teach the industry a lesson?
I certainly think that is part of the EEOC's approach, is to utilize these types of cases as a lesson. I don't know that you can expect to see that level or that number in all cases, considering sort of how the litigation transpired and the fact of the default judgment here, but certainly there is a risk.
Yeah, and likewise, this company, this case, and this is the last case we'll talk about from this past year or so, but this last case, this has just happened May, 2 months ago, and, $1.2 million case. I mean, what happened here, Cameron?
This is another one of those examples where it depends on the nature of the circumstances that the EOC sees and how, what it wants to do to affect change. It's interesting that this case only had a 2-year consent decree, and why exactly that was as short as 2 years is unclear. But multiple employees were subjected to the problems that in this particular situation. And because multiple people were affected in one way, and then there was a second element to it when there was retaliation implemented, I think that's one of the reasons why in this particular case, the EOC, as this slide shows, wanted to be a little bit more engaged with it, having an EOC liaison person to actually pay attention and watch. And one of the things that can mean, it doesn't mean the same thing in every situation, but one of the things it can mean is that the EOC has a right to come out periodically, not necessarily unannounced, but with relative short notice period, to conduct interviews, basically do a checkup on a project site. It has the opportunity to talk with people. How are things going? Have the policies been implemented? Have the behaviors changed? If you get to the point with your consent decree that the EOC is actively engaged to that level, then it can be a very frustrating effort for the company. And keep in mind one other thing too, I think that's noteworthy about, we've spent most of our time talking about the EOC, and that's certainly the purpose of today's presentation. But federal agencies talk, they communicate. They may or may not share information among each other. OSHA is actively working on this issue while other agencies are looking at this. So there probably will be some sharing of information along the way. But the EOC particularly has extremely onerous consent decree powers that not necessarily all of these other companies have to the same degree.
Well, that's a good segue into this next topic, and I want to make sure we're getting to the meat of what can people do to protect themselves and be proactive. And we talked a little bit about like what a consent decree means and what it looks like. So I guess what is the expectation of conduct under a consent decree, and how could that affect businesses?
We've talked about a lot.
Whoever wants to jump in, yeah.
Yeah, sure. I'll take a run at this. And I do see we're winding close to time here. We've talked a lot about consent decrees and what they do. And just as a quick overview, they can contain several things, including but not limited to the following types of things. They have a lengthy period that they are in effect. There's a monetary payment. There's injunctive relief against certain conduct by the company, by supervisors, managers, et cetera. There's somebody usually appointed to actually implement the terms of the EEOC consent decree, which can be an external person. It doesn't have to be, but it could be a consultant from the outside who is somewhat objective. Training for managers, training for employees, and that training is often training that has to be approved in advance by the EEOC. It's not just something you can buy off the internet or call your neighbor to come teach you how to do something. Neutral letters of reference, we've talked about that. Revised policies and procedures. Even if you have P&Ps in place, the EEOC can make you revise them and focus on certain aspects of them. Posting notices on your wall, on your project sites, informing everybody who comes on site of what occurred. A, that there was litigation involved, and B, that it was resolved. Sometimes not only that it was resolved, but how it was resolved, the details of how it was resolved. Periodic, extensive, substantial reporting to the EEOC. The EEOC has multiple layers of reports that it requires. Certification of compliance. The person responsible for implementing the policies under the consent decree, in all likelihood, is going to have to sign a certification that certain things are being performed and done correctly by the company as a result of the consent decree. Additional kind of EEOC follow-up. It can come back on your project site. It absolutely, once it gets these reports you filed, if it sees something that it doesn't like, it's going to come back out. That could result in an extended time period of the consent decree. It could result in additional investigations. The bottom line is an EEOC consent decree can be one of the most onerous things that you have to operate under while you are also trying to build projects. It is a morale defeater. It is a financial harm and hit to your business. And it is considerable red tape and bureaucracy that you have to deal with. It is a very frustrating thing that we want you to avoid as much as you can.
So should we be concerned as an industry that the EEOC will just drop by and investigate the business, stop by any job site and kind of peep around and see what's going on? And if that's the case, how do you react? What are your next steps? Beth, do you have any suggestions? Do you have any ideas of this is something that can actually happen?
First and foremost, the EEOC has investigative powers even without a consent decree. I want to back up and point out with respect to what Cameron said. We had a question come in. Should companies pursue other alternatives in order to avoid the possibility of consent decree? Absolutely. Is there a best case scenario if you're in the situation where you're likely to get hit with a consent decree? Absolutely not. There is no best case scenario. It is extremely onerous. Avoiding them is not getting one is the best case scenario. And so, yes, there will be investigative issues in connection with a consent decree, but those types of investigative issues can arise even if we're just talking about a charge of discrimination that was filed. The EEOC has the power, once a charge has been filed, to investigate your company. Yes, they're going to give you notice, probably not much. If you refuse, they have what's called subpoena power. They can issue a subpoena and require you to provide the information and allow the inspection and allow the interviews of your employees. The answer is yes. And there are courts that will say there are some limits on the EEOC's subpoena power, but I'll tell you, they know how to write them correctly to get far beyond just the information related to an individual charge and have a lot of power to create what's called commission charges and go even beyond the job site, the segment of the business, and go into far-reaching areas.
So, Beth, what are they looking for in these investigations?
So, you know, in these investigations, they're looking for exactly what's laid out in the report. And I echo what Cameron said. If you've got the time, I would recommend digging into it and getting acquainted with it. They're looking for, you know, what does your data look like among your employees? Are all of your women and people of a minority holding low-paying jobs? You know, they have your EEO-1 data already, so they're going to take that and compare it to where those people are working and question whether you're working to promote and give opportunities. And so we've talked a lot about the, you know, what to expect. I think it's time to talk about what to do to prepare. And, you know, I'll let Cameron weigh in on that one first.
Yeah, please. I think this is what everyone's dying to know. What can we do to prepare? What can we do to protect ourselves?
Yeah, thank you very much. And to the extent we're not able to answer your questions today, folks, please don't hesitate to reach out to us or to some other attorney that you work with to ask the questions that you have. The first thing I would do is absolutely acquaint yourself with this report. I think you need to be very comfortable with what it says, what you think its objectives and goals are. However you interpret why it's being done, at least appreciate that the EEOC intends to do it and that it's got a bank of resources that it plans to follow over the next couple of years. Once you've done that, look at your own house. Keep your own house in order. Check your policies and procedures. Are they updated? Are they current? Do they have all the recent laws in them? You may need to revise those. Number two, implement training. Make sure you have training in place and periodic training and training of different kinds. It might be training for supervisors, manager level. It could be training for employees. There are different types of training that you have for those segments of folks. Look around. I mean, just open your eyes and look around your project site, your office. What does your office look like? Make sure you have in place policies and procedures for handling these types of complaints when they come in. Know what you can do internally to investigate them, to figure out what happened. Someone asked a question earlier about ways to possibly avoid the EEOC consent decree, which I completely think you should do. We all agree with that. Train, clean up your own shop first, make sure things are in order there. If you do get a claim, take it very, very seriously. If the EEOC comes knocking, absolutely explore the conciliation process. Absolutely try to avoid as best you can active, engaged litigation in which you have to end up with a consent decree. Beth, I know you want to add some things to this.
So I agree with everything you said, and then I come down to be willing to think outside the box. Because if you've got your toolkit in order, if you've got your training done, and I say not just training periodically, but in-person trainings, because I think that's a big focus of the EEOC too. But if you still have an issue arise and you still find out that a charge has come through, my recommendation is to be ready to think outside the box. Don't treat it like your typical charge you have received over the last few years, because I don't think the EEOC is going to. Consider things like the EEOC's mediation process. If you can get a claim resolved at that stage, that means you don't make it even to the investigation phase where they can start asking questions. Now, they may not be offering that option as often or as frequently to the construction industry given this focus, but it's certainly something to think about. think about the opportunities for partnerships and coalitions. One of the questions that came in is, how do you get involved in something like that? Well, we don't know yet because the EOC hasn't put out the information on that, but certainly we are monitoring. We will keep you apprised of when those opportunities start to develop, and you may receive outreach from the EOC directly. And if you get that type of outreach, don't be afraid to loop in council, let them help you navigate that partnership or coalition. And then, like Cameron said, conciliation is another option that if it gets that far, it can be done confidentially. And I know some companies that refuse conciliation. I would definitely recommend against refusing, given the focus on the industry. And there are a number of other things that we could talk about that are particular to your business and your program. If you're interested in talking through best practices and approaches to protecting and prevention for your company.
And that's a great way to end, Beth. Thank you so much. And, thank you, Cameron and Beth, so much for your participation and wisdom. For everyone still on, I know we're hitting the hour. But if you did not get an answer today because we ran out of time, please feel free to reach out to any of the three of us. We all have experience in labor and construction employment. Beth and Cameron, especially have tons and tons of experience and knowledge that they're willing to share and help out with any individual problems that the companies might be facing. Please feel free to reach out to the three of us. And we thank you so much for your participation and for being here with us for this hour. This is our contact information. Please connect with us, visit our website, visit our Twitter, and you'll be getting a copy of this presentation. So thank you all so much for joining us. Thank you, Beth and Cameron, again.
Thank you, Maya. Thank you, Beth. Thanks, everyone. Have a great afternoon.
Have a good one.